5 seconds to go. Start. In view of the aforesaid discussion and conclusions, we find that there is no conflict in the three judge bench decisions of this court in B. Jayaraj and P. Satyanarayana Murthy with the three judge bench decision in M. Narsinga Rao, with regard to the nature and quality of proof necessary to sustain a conviction for offences under sections 7 or 13(1)(d)(1) and 2 of the Act, when the direct evidence of the complainant or primary evidence of the complainant is unavailable owing to his death or any other reason. Stop. The position of law when a complainant or prosecution witness turns hostile is also discussed, and the observations made above would accordingly apply in light of section 154 of the Evidence Act. Stop. In view of the aforesaid discussion, we hold that there is no conflict between the judgments in the aforesaid three cases. Stop. Para. Accordingly, the question referred for consideration of this constitution bench is answered as under: para. In the absence of evidence of the complainant, direct, primary, oral, documentary evidence, it is permissible to draw an inferential deduction of culpability, guilt of a public servant under section 7 and section 13(1)(d), read with section 13(2) of the Act, based on other evidence adduced by the prosecution. Stop. Para. We direct that individual cases may be considered before the appropriate bench after seeking orders of Honorable the Chief Justice of India. Stop. Para. Before we conclude, we hope and trust that the complainants as well as the prosecution make sincere efforts to ensure that the corrupt public servants are brought to book and convicted, so that the administration and governance becomes unpolluted and free from corruption. Stop. Para. In this regard, we would like to reiterate what has been stated by this court in Swatantra Singh versus State of Haryana 1997 for SCC 14. Para. Corruption is corroding, like cancerous limb nodes, the vital veins of the body politic, social fabric of efficiency in the public service, and demoralizing the honest officers. Stop. The efficiency in public service would improve only when the public servant devotes his sincere attention and does the duty diligently, truthfully, honestly, and devotes himself assiduously to the performance of the duties of his post. Stop. The reputation of corruption would gather thick and unchaseable clouds around the conduct of the officer and gain notoriety much faster than the smoke. Stop. Para. The above has been reiterated in A.B. Bhaskara Rao versus CBI 2011-10 SCC 259 by quoting as under from the case of State of MP versus Sambhu Dayal 2006-8 SCC 693. Para. It is difficult to accept the prayer of the respondent that a lenient view be taken in this case. Stop. The corruption by public servants has become a gigantic problem. Stop. It has spread everywhere. Stop. No facet of public activity has been left unaffected by the stink of corruption. Stop. It has deep and pervasive impact on the functioning of the entire country. Stop. Large-scale corruption retards the nation-building activities, and everyone has to suffer on that count. Stop. Para. We place on record our appreciation of all learned senior counsel as well as counsel and instructing counsel, including learned ASGs who have assisted the court. Stop.